and seconded. SB 42, 160, 233, and 865. Anybody object to the unfavorable? Seeing none, those four bills will be on a consent calendar, unfavorable. Okay, we will go to list 22. I don't want to get bogged on that one. We'll come back to 221. We'll come back to that. But let's start with 467.
On number 22.
On 22, 467, Ms. Foxworth.
Senate Bill 467, Business Regulation, Home Improvement Commission Award Limits. This bill increases the amount the Home Improvement Commission may award from the Home Improvement Guarantee Fund from $20,000 to $30,000 for losses caused by a licensed contractor. No amendments.
Folks, you have a packet, a thick packet with a list, and then there is a smaller, thinner, freestanding list. They're different. The thin one should have been the one attached to the packet. So in other words, on the thin one, the second bill is 413, which I didn't realize, and I skipped that. We're going to stay with Ms. Foxworth on 467, but we're going to work from.
There is no 413 on either bill.
No, there should be on every desk. Look again. A two-page voting list. No, does anybody have a two-page voting list?
Yeah.
No.
We have 22, 23, and 24. We've dispensed
Okay,
with 24.
do we have more over there? Okay. Anyway, there's a small correction. Don't get confused more than we need to. I apologize. We're on 467 with no amendments.
22.
467 on, yes, it's on both lists. Is there a motion to put it before us? It's moved and seconded. Discussion or questions? This increases the award limits by $10,000. Discussion. Seeing none, would anybody like to be voted in the negative on the affirmative motion? Seeing not, 467 will go to the floor as favorable. Let's go to 497.
Senate Bill 497, Deer Management Permit, Hunting on State Land Leased by Permit Holder Authorization. This bill authorizes a person hunting under a deer management permit on state land leased by a permittee for the cultivation of crops to use a shotgun or breech loading center fired rifle approved by the Department of Natural Resources to hunt deer throughout the year, including all deer hunting seasons, in the locations and under the conditions set forth in the permit. There are no amendments, but I would note that DNR recommended at the bill hearing that they should be given discretion rather than just saying overall that it should be that anybody is allowed to do this.
Let's get it before us. Senator Gallion moves, Senator Riley seconds. Senator Gallion, to you.
Thank you, Mr. Chair. It's my understanding that there was an amendment on the House side on this. Did we get that?
No, not unless
It was
somebody
about
gave
author.
to me.
It was, I guess, off of DNR's letter of info, but they didn't actually put in a. I know they didn't reach out to me to put it in. But
Senator, what do you think it does or says? Do you know?
Tell you the truth, I just heard about this a little while ago, so
Could it be the same one that Ms. Morton just mentioned about softening to authorize rather than require?
it was off of DNR's, based off their letter of information.
and that's, they were the ones who recommended saying authorize rather than require.
I mean, I'd be fine with that, and if it will match it up to what, I think the House just passed that out of subcommittee.
I will see if I can get a hold of their counsel and if we can take a look at it.
We'll come back to this,
Okay, thank you.
hopefully later today. Uh, 501.
Senate Bill 501, Maryland Higher Education Commission Procedures Alterations. This bill requires that by April 15th of each year, the Office of Student Financial Assistance send notification to each individual who applied for a Delegate Howard P. Rawlings Educational Excellence Award, indicating whether or not the student is a recipient of an award, and if applicable, the amount awarded to the student. Additionally, each open meeting of the Maryland Higher Education Commission must be made available to the public through live video streaming. MHEC must make a complete, unedited, archived video recording of each open meeting publicly available on the internet for a minimum of 5 years after the date of the meeting.
Are there any amendments?
There were no amendments in the Senate. I showed you the House ones, and you said you wanted to talk about them, but I didn't
Okay.
include, I have a copy if you want me to hand them out.
Again, we're our own chamber, and we can just move as we see fit. Obviously, we don't want to always reinvent the wheel. So I'm going to ask Ms. Goodman to just briefly mention what they do. It might spur an interest for us to adopt it. We are not pledged or required to be moved to adopt it or even consider it.
Okay, the House amendments would require MHEC to design and implement a scholarship application that results in the applicant applying for all the centralized scholarship programs available in the commission before July 1, 2025. It authorizes the comptroller to release tax information to MHEC to facilitate the verification process of student data needed for the various scholarships, including these Education Excellence Awards. It requires MHEC to update regulations to move up deadlines to award promised scholarships consistent with the award dates for Educational Excellence Awards under the bill. And it provides that the intent of the Maryland General Assembly is that MHEC reorganize to establish the Office of Student Financial Assistant as an separate independent agency in fiscal 2024.
Look, it is significant, and we can have some of these discussions later, and we don't have to have them now. I just wanted us to, look, MHEC has been somewhat of a challenge, and the scholarship administration has some challenges too. And they are suggesting that we split off or study splitting off the scholarship administration as a separate agency. So they aren't before us, you know, right now it's basically the bill to change the dates. The House Higher Ed Subcommittee would like to take this on in a more significant fashion. So I'm just throwing that out there. Let's get the bill in front of us first. Even in basic form, it's been moved and seconded. Discussion on the bill or possible amendments, Senator Corrosive.
I agree, Mr. Chair. I think the amendments are significant, and we have not had the opportunity to vet them, so I would not be supporting the bill with those amendments.
If no one moves them, they're not before us. Okay, so the bill is in front of us, unamended, understanding that the House might want to have conversations later. Discussion on the bill without amendments. Seeing none, does anybody wish to be recorded in the negative on the favorable amendment? Seeing none, the bill will go to the floor 9-0. That's 501. Let's go to 538.
538, land use agritourism definition. This bill establishes that the definition of agritourism under section 4-212 of the land use article includes special events and occasions conducted on a farm that generates income from an agricultural activity.
It's moved, it's been seconded. Discussion on the bill? Seeing none, anybody wish to be recorded in the negative on the favorable? Seeing none, 538 will go to the floor, 9-0. 582.
582, natural resources, recreation on private land, hunting. This bill establishes that if a landowner directly invites or permits without charge an individual to use the landowner's real property for hunting, the invited or permitted individual impliedly consents to adhere to every law, to observe every safety precaution and practice, to take every precaution against fire, and to assume all responsibility and liability for the individual's safety and property while hunting on the landowner's real property. There are no amendments.
It's been moved, it's been seconded. Discussion on Senator Bailey's Bill 582. Please, Senator.
Yeah, thank you, Mr. Chairman. So I live kind of like in the country area of Charles County, and certain times it's, folks are like, on the guise of hunting, like just really shooting off their firearms. And, I get a lot of calls from my neighbors who know I'm a senator and say, hey, what can you do about it? So my question is, will this bill create a right for a private landowner to have as many people on his or her land as possible whenever to hunt? Is there a back door that we're opening with this? I don't know if you can answer that.
To the expert, I can't answer that.
Yeah, so, right now, there's not really a limit that I'm aware of on if you're a private landowner, how many people you can have coming over to hunt. What this bill is dealing with is, it's addressing, so there is already a law in place that says that if you open your land to public recreation, that you, as the landowner, are not responsible for people's safety, essentially, while they're using your land. So it's a way, the law was initially a way to sort of encourage private landowners to open up their land to the public. There was a recent court decision, so that has always been interpreted to apply in the past to private landowners who allowed people to hunt on their land. There was a recent court decision that said basically that provision only applies if you allow like everybody, like all of the public, and it doesn't apply if you just invite like particular friends over or just specific people. And so this, I think, it's trying to sort of take the interpretation back to the original interpretation.
And so that original interpretation was, can you summarize that again, what the original?
Senator, I think it doesn't change the hours, it doesn't change the number of people, but it explicitly says that the people who the owner invites or allows on, they accept all liability and the owner doesn't have liability.
So without liability, that's telling me there's no responsibility.
No, it's shifted, Senator. It's, in other words, this is to make it abundantly clear that it's not the property owner who has the liability, it is a person who potentially does the damage. So it's the invitee has liability. It's not like everyone is free of liability. It just makes it clear, if I say you can come on and you do some damage, civilly or whatever, and someone comes after, they aren't coming after me, they're coming after you.
Yeah.
Is that-
Yeah.
Is that,
Yes, and I apologize, I just realized there is an amendment. It was,
let's stay with this first.
yeah.
Yeah. Yeah. So if we take it from hunting to, say, any of our neighbors with a bad dog, if that neighbor could have any kind of bad dog that bites up his neighbor's children and say, well, we take the liability away from the homeowner who has a dog and put it on the dog, then the owner then would have less care in watching out about the amount of bad dogs he or she has on their property. So I don't know if that follows through to the fact that if one of my neighbors who invite people on their property, they have no liability, that means they don't care what that person do. So, hey, I'm not going to watch out for my neighbors in any dangerous situations or, just anything like that, in that I have no liability personally. I'm not sure if I'm following what the bill is saying with this line, but could you let me know if dead on or far off?
Senator Riley.
Thank you very much, Mr. Chairman. The bill is very, very small and short, but I got some information from the fiscal note about the current law. Under current law specific to hunting, a person must obtain written permission from the landowner. The person hunting on the private property is liable for any damages he or she causes. The landlord is not liable for accidental injury or damage. So if I'm a hunter and I've got a gun on the property and something happens, I'm responsible. I better have a piece of paper in my pocket with the landowner's signature. Otherwise, I was trespassing and can be locked up. So there are checks and balances under the current law, and I don't think the bill changes that. So I'm very much in favor of this bill, Mr. Chair.
So what's this bill doing? What's it changing with current law, Senator Riley?
I think there was a court opinion that confused the issue, and this is to make it clear, but Ms. Morton?
Right, so, and, I mean, to some extent, Senator Ellis, I mean, you were correct that it is absolving the landowner of responsibility for damage for accidents that happen, that the hunters kind of make. Again, in the past, that has been, it's the kind of our recreational use statute. It's more about, and I will say, I'm not so sure about how the law really applies. For example, I guess the law really talks about accidents that happen, responsible and liable for the individual's safety and property while hunting on the landowner's real property. So I think the statute is really more about whether or not the landlord is responsible if the hunter themselves gets injured or harmed, rather than for damage that the hunter causes, at least in the terms of the statute. And I don't know how it has been applied to things like that, where potentially somebody invited onto the property causes damage to somebody else off the property. I just don't know.
I would love to get an answer on that before we vote on this, because, especially for rural areas, this is a really large issue, and we don't want to create a free-for-all where no one who is responsible for who comes on their property is really responsible for any damage that person caused on their property. That would create a particularly difficult situation. So I'm not sure if we can get a clear ruling and who to go to make it seem, if we can get that ruling, or if amend the bill to make it clear about, that particular issue.
Senator Corrosive.
Thank you, Mr. Chair. I just going through the testimony, the hearing file, that was no unfavorable. And I noticed that the Maryland Department of Resources said it was an important bill, and also that DNR and the Maryland Farm Bureau were both proposing amendments, and I know council was about to I was trying to figure out if those were combined amendments or what actually they recommended and what we're considering.
amendments, and I'm sorry, I missed it and forgot to distribute it, but they are attached to Senator Bailey's testimony. It basically just makes a conforming change to another statute, section 5-1106. And this actually gets a little bit to Senator Ellis's concern. The amendments 5-1106 talks about, the provisions of the subtitle do not limit in any way any liability which otherwise exists for willful or malicious failure to guard it or warn against a dangerous condition, use, structure, or activity. So again, the intent of both the existing statute and as this bill is trying to kind of bring back the pre-existing interpretation, just talking about negligence and accidents. But so the Senator Bailey's amendments, again, they're attached. If you look in your online testimony, you should find them. And then just amends another part of that section that says, because the statute says the subtitle does not in any way limit liability for injury suffered where the owner of the land charges the person who enters or goes onto the land for recreational use, and this would say except as provided in 5-1109, which is this statute. So again, even if they're charging for people to come on and hunt, the landowner would not be liable.
Yeah. Is the amendment in the packet?
It's not in the packet it should be in your bill file online, because
Okay.
he did submit it as part of his testimony.
Okay.
But I missed it. for the
Senator,
packet.
going back to your question, your fundamental question, and again, I am not an attorney. I sometimes play one, but as I read this in plain language, the invited or permitted individual who uses the real property for hunting and consents to adhere to every law, et cetera, assume all responsibility and liability for the individual's safety and property while hunting on the landowner's real property. I think that's pretty tight, I think. So in other words, if they fall or trip, or they shoot themselves, the liability's on them. It's not on the person who let them come on their property. I mean, if it's vague in your mind, I'm happy to slow this down. I'm just not sure, I guess I'm not sure what your concern is. And I want to hear it. I don't want to push this through. I'm agnostic, basically.
Yeah, so that example, I understand. I have no problem with that example you just used, Mr. Chairman. So I'm concerned about is a bullet leaves the border of that landowner's property and go to the neighbors. So if that property owner have a busload of church members coming, they pile off and they start, going all over the place, not knowing the borders of that property or how far that neighbor's home is, and that bullet from whatever kind of weapon they're using travels and cause damage to a neighbor, they can't see through the woods. If that landowner who should be responsible to supervise visitors to his or her own home did not do that because he knows or she knows there's no liability, then you'll have neighbors getting harmed. And who do you go to? What if, the person who caused the negligent action, is uninsured, doesn't have a home, doesn't have homeowner's policy that would cover, then the neighbor who's harmed will have absolutely no recourse at all to pay for whatever physical damage to property or person. So I care more about, in the context of this bill, the neighbors and liability and responsibility.
Let me ask committee counsel. I mean, that situation could happen now. So do we know where the liability falls? In other words, this is why the equine people always come up. of bullets don't stop at a property line. I mean, that's not a new issue. We have it all the time. If a bullet strikes a horse, we'll say, off the property, do we know if it's the owner or the person who shot the gun, or is there no liability because they're allowed to hunt?
It would certainly, the person who shot the gun would certainly be liable in any case. The question is whether the landowner would be liable. Absent this bill, absent any other thing, I think it would be up to debate. It would be a question for the courts to determine whether or not that landowner is responsible, to the extent to which they are responsible for sort of supervising people on their property. But I think Senator Ellis is probably right. There's a pretty strong possibility that absent this bill, the landowner might have some liability there. This bill would, and he's correct, it would say the landowner's not responsible. It's on the hunter to take all the necessary precautions and bear any liability from their actions.
Okay. What's the committee's wish? I mean, I will say this, and again, I'm not an attorney. Under current law, if hunting is allowed on this property and a bullet goes beyond the property, I'm sure the defense is going to say, I'm allowed to hunt on this property. And I don't know how the courts would rule, but I think that's been an ongoing issue for years. It's not new. Senator.
If I may, if you shoot and kill a cow or a horse or hit a house or hit a person, you're responsible. Now, whether or not you have assets and whether or not you have insurance, we face that every day in our world. I mean, not every car, 12% of the cars on the road in Maryland don't have car insurance. I understand the need for people to get to and from work and get their kids back and forth, but at the same time, what about the innocent party? So there's a certain amount of risk for living. I think this squarely clarifies that the person carrying the gun is responsible. This is also in the same part of the code having to do with snowmobiles and cross-country skiing. Somebody's driving a snowmobile in the middle of winter, and the thing tips over and the rider or the driver breaks their back, the owner's not responsible for that, nor should they be.
Yeah, but Senator, I looked at that too, but the new language is for hunting.
Right, I understand that.
Right.
But it's in that, the fiscal note clarifies it. Again, the bill's very short and as you said, tight, but I'm just going with the rest of the fiscal note, which I think is very clear. We want to make sure that if I say to someone, yes, you can hunt the deer on my property, and, if you shoot your foot off or you shoot your partner, Vice President Cheney, it's your responsibility.
Okay. Senator Gann, you want to speak to this? I know, I don't want to put you on the spot, but.
So I've had, farms I've rented where I have cattle, and I've had hunters almost right up on the property line. I've never one time had an issue with a straight bullet or anything like that, and I've got a pretty good herd there. I mean, I think the hunters are, they take the safety classes and they're pretty careful. I mean, the last thing one of them would want is to hurt someone else's animal or property or, God forbid, a human being. So, I'm comfortable with the bill and, be voting in favor of it.
So I appreciate my colleague's point of view, but that's before this bill is passed, okay? That care is there before. This bill, I'm concerned, will take away that care. And it's a serious issue. I would hate for us to rush to vote. I would ask if we could hold it so I can reach out to maybe the Attorney General to see rights and responsibilities, because this is a serious issue. It's not a simple issue. I mean, like I said, I live in the country with acreage, and it's not just, hey, accidental bullet came in, and it's more serious than that. And I hear the comments and questions from my neighbors and others, and my community. And so it's a really serious issue that so many of my neighbors are concerned about already, reaching out. So I would love to be sure before we vote that we're not creating a situation that will authorize the wild, wild, wild west in our rural areas.
I'm going to give it a day. I'm trying to move as many bills as for crossover. And there's some other bills we're going to be dealing with in the next few minutes that are somewhat controversial. And this is not a guaranteed hold for every bill, just so people understand it. I think it's a genuine concern. Hopefully, we can still move it in time. So we'll give it to a voting session tomorrow. And then you can vote no. I mean, a lot of times we don't get our views and opinions affirmed. Hopefully, you can get a better answer. So if it'll allay any fears, and you can vote yes, or if you think it stinks, vote no, which obviously you have a right to do. So I'll give it 24 hours. I'm not guaranteeing a hold on any other bills people have concerns about, but that's a hold. Okay, let's go to 606.
Senate Bill 606, Baltimore County Alcoholic Beverages Licenses Transfers. This bill authorizes the Baltimore County Board of License Commissioners to approve the transfer of up to 5 Class B or Class D licenses from Election District 15 as specified. The bill prohibits the board from transferring more than 2 licenses into any single election district. The bill removes certain restrictions relating to Class B service bar, beer and wine licenses in the county. The bill also makes technical changes to remove outdated language related to expired dates by the board, was previously required to approve the transfer of licenses. There is one amendment in your packet on page 69 from the sponsor, Senator West. And this provides that the board may approve the transfer of the Class B and D licenses from an, quote, eligible transfer district, which is defined, instead of election district 15, if the approval occurs between June 1, 2022 and May 21st, 2025, subject to other conditions. On receipt of an application for transfer, the board must notify the Baltimore County Department of Workforce and Economic Development and authorizes the department to submit a letter to the board regarding the economic impact of the license transfer will have on the surrounding community. It also provides for information that must be included within the application. There was no opposition, and we have received a local letter.
Is there a second? Second. Discussion on 606? Seeing none, we will move it to the floor as favorable with a 9-0 vote, 2 absent, Hester and the vice chair.
We were able to get that figured out on that bill we had to skip. I didn't know if we won't need the amendment, so make it, it's up your discretion, but that'd be great if you wouldn't mind.
Okay, we have 497 before us. It was already moved and seconded. Senator, repeat, please.
We had a little miscommunication on the amendment issue, so I spoke to April, let her know we won't need it, so we can go ahead and, I'd like to go ahead and move it clean without.
Any objection to the favorable without amendments? Seeing none, it goes to the floor 10-0. 638.
Senate Bill 638, Public Schools, Student Athletics, Requirements and Reports, the Elijah Gorman Act. This bill requires, beginning on December 1st, 2023, that each local superintendent of schools submit an annual report with specified information on public high school sports teams to the Maryland State Department of Education. The bill also alters the requirements for local boards of education regarding automated external defibrillator programs and I can't say that word, guidelines for student athletes as specified. There is one amendment. It's in your packet on page 73. It's offered by the bill's sponsor, Senator Heddleman. This amendment strikes the provisions requiring the reporting of sports teams to the department. It requires each middle and high school to develop a venue-specific emergency action plan for operation and use of AEDs and heat acclimatization. It clarifies that each county board's preseason practice guidelines for student athletes must be consistent with a certain model policy developed by the department, the Maryland Public Schools, Secondary Schools Athletics Association, and other stakeholders. It requires the state board to develop and implement an educational program for student athletes on signs of heat stroke, concussion, brain injuries, and associated protocols, and requires all student athletes to attend that program. And further requires all middle and high schools to adopt a venue-specific action plan for all athletic facilities and provides for the contents of the plan and reporting requirements. I bring the committee's attention to what the contents of that last piece is to take a look, because there's some very specific things in there. Again, that amendment starts on page 73.
Okay, ladies and gentlemen, it's a fairly significant rewrite. The first half of the bill is dumped. It was very, I don't want to say micro, it got into very explicit detail and had a lot of demands on the local LEAs and the sports programs to have the cold tubs at all practices, not just football in the summer, and the defibrillator. So it's scaled back, if I can summarize, to develop a plan.
Still takes some of that and puts it in the new, and that's what I want you to take a look at. On pages 76 and 77, some of those provisions regarding the AEDs and the cooling methods migrate into this new plan. And they can be pretty significant costs or requirements. The committee should take a look.
Words, I want us to know what we're voting on. So on 76, for example, it says defibrillator must be on site and located within a 2-minute walk from an athletic practice facility. So the other one, it said it had to be on site for a game, I think, and a practice, which is almost impossible when you've got 3 activities going on. So I think it's been scaled back, particularly for defibrillator and for the cold tub, particularly for summer where heat is a problem. But why don't you just take a minute, if you would, and just look. Obviously, it doesn't have the strikeout, but if you have the bill in front of you, everything up to the middle, the bottom of page 3 is out. All of 2 and 3, and then the bottom of 4 and top of 5 is out. And then you have this new language before you. So let's just take a minute. We're on 73. And why don't you just take a minute to skim, because I know this is pretty new. Let's put it before us. It's been moved and seconded. Senator Corrosive.
With this rewrite, would the council know, or has anybody checked to see if it's doable on the local end as far as, I know in my counties, we have pretty big sports programs, like most of you all, just to know if this is just workable, since it's had a major rewrite. I know some of the organizations weighed in, I think, on the hearing end, but I didn't know if it had been taken back to them at this point.
Or another way, MABE, for example, supported with amendments. So does this new rewrite address their amendments?
In their testimony, may specifically objected to this cold immersion provisions with the stock tanks or the pools. And they had some concerns about the number of AEDs that would be required under the previous bill. I think some of the AED concerns were addressed, but there was still some concerns about the cooling methods. You know, it would mean that there would have to, every school that had these programs would have to, it says a stock tank, inflatable pool, or other appropriate cooling method, but it's not defined what that would be. I don't know if that's a hose that you could cool people down, or, you know, I mean, that's on page 77. So it says that each school is properly prepared and equipped to initiate cold water immersion for the treatment of exertional heat stroke. Ensure that the cooling modality is a stock tank, inflatable pool, or other appropriate cooling method. Set up and available when the wet bulb globe temperature is at above 82 degrees Fahrenheit, or the heat index is at or above 95 degrees Fahrenheit. Readily available to student athletes at all athletic practices and events on school property. Ensure that all members of the coaching staff are trained in cold water immersion, and ensure that trained member of the coaching staff is present at all athletic practices and events on school property. So that's still pretty prescriptive. And just for you aware, a wet bulb globe temperature is a measure of the heat stress in direct sunlight, which takes into account temperature, humidity, wind speed, sun angle, and cloud cover. This differs from the heat index, which takes into consideration temperature and humidity, as is calculated for shady areas.
Add to that.
Yeah, let me ask a question, then I'll go to the Vice Chair and Senator Riley. Is anywhere explicitly said this is for outdoor, not indoor? I mean, I don't know if a gym would ever get over 82 degrees, but, and I know most of this, Jordan McNair died outside at a summer practice in August when it was horrible, the heat, and they had a double practice or whatever. But I guess my question is this outdoor or indoor?
No, there's nothing that specifies it's only for outdoor. And a part of the MABE concern was that it doesn't differentiate between different sports. So, for example, it might not be appropriate for every single type of athletic event. So the committee may wish to consider some limiting language that has them consider those factors before this would be required to be set up.
Okay, let me go to the committee members, Vice Chair Kevin, Senator Riley.
What council just said, I'm finding a little provocative, actually. What sport wouldn't that cover? Because I'm thinking cross-country, soccer, field hockey, obviously football, baseball. I mean, I'm trying to think of a sport that wouldn't involve people possibly getting overheated, certainly if it's an outdoor sport, but you can respond to that. I just wanted to add to the wet bulb globe. Apparently, one is donated to every single high school, so I'm waiting to find out if they are also donated to middle schools, since this bill covers both. I also did a quick Google search, and they range in cost, if the middle schools had to buy them, from $175 to $600. So I assume there's some variety of quality reflecting in the variety of prices. Thank you.
Thank you, Mr. Chairman. I love the intent. I love the training. I love the AED. I love that every parent and athlete has to be made aware there's an emergency plan. So all those things I find great. Madam Vice Chair, wrestling, volleyball, weightlifting, gymnastics, things of that nature, especially wrestling. These young kids trying to lose a little weight, they heat up the room, they put on their plastic outfits to lose a couple of ounces to try to make weight. But I don't know if the immersion tank and others are necessary as long as the training includes the understanding of the implications of the heat and the adverse effect on their athletes. So again, it's an emergency plan, training and awareness. I'm all in. The immersion stuff is problematic for me. And number two is, I'd never heard any of the testimony that says middle school is a problem. So those are my comments.
Moved. I think everyone in this room is going to be interested. July 19th. Damn. Back to the sports. Good question. Who knows, right? Anyway, more as we learn it. Does it affect the filing deadline? I will find out. I will let you know.
Okay,
It does affect there are new dates for everything now. Yeah, they have to change. April 15th. April 15th.
Right after we adjourn.
okay,
Damn.
Yeah, April 15th.
this is screwed up.
22nd is gone?
Oh, my God. Right.
Horrible.
We're live streaming.
We are live streaming.
Yep. Okay,
Democracy in action, folks.
Senator Riley, in response to your comments, if we took this section and said it applied to outdoor sports and then limited indoor seasons or sports to being aware of these problems and concerns, does that get us closer to where you're suggesting?
Yeah, middle school.
Well, middle school is never in it.
Oh, I'm sorry, I thought it was.
Yeah.
It is.
Yeah, middle and high.
That's why I brought it up.
These provisions apply to both middle and high school.
Yeah. That's what I was asking you.
Sorry. Oh. Okay. So let me ask a question then. If they don't have interscholastic sports and they have intramurals, what part of the bill would apply to them, I guess is my question.
It doesn't specify that they have to be part of the MPSSAA. It just that they have to be athletic events. It's pretty, it just says student athletes. Let me pull out the bill here, make sure I'm. Let's see. Right, it just says the middle and high school shall develop a venue-specific emergency action plan, subject to 7450. And it just mentions middle or high school students in athletics. It doesn't specifically say whether it's intramural or interscholastic or.
Okay.
74 just says student athlete.
Yes.
Folks, what's the pleasure?
I would be happy to offer to lead a small, tiny little work group of a couple of colleagues who might want to join me, and we can either include Senator Hettleman or not, or whatever, but include some of the key stakeholders and just have a brief conversation about it. I think, I mean, this is one of those, it's not a hypothetical. We've had young people die, and I think having a reasonable, affordable, prudent solution would be a good idea. So I'm volunteering to either be a part of it or lead it if there's someone else who will be a part of it.
Senator?
Another option is to make it a study.
I don't think we ought to wait a year.
Okay,
That-
just a suggestion.
So I think that's a fallback position. I'd
Okay.
like to start with the primary option of doing it.
That's fine, just a suggestion.
You in?
Let's try to take it up tomorrow night, though, the next 24 hours. I mean, look, I think part of this, the first part of the bill has been trimmed down, it's pretty clear, and it's more flexible, like the defibrillator being within a couple of minutes. I think the cold tank is really one of the sticking points. And we can either trim it back, as we've discussed, or we can cut it. But let's try to move as much of this bill as we can. So it doesn't give a lot of time, and, maybe after the voting session, if you want to take a half hour, 20 minutes, if Ms. Goodman can stay with you and just do the best you can. I'd like to do it with crossover if we can. Okay, that makes 638 a hold. Let's go to 654.
Senate Bill 654, Veterans Affairs, Office of Communications and Public Affairs, Veterans Advocacy and Education Act. This bill changes the name of the Outreach and Advocacy Program within the Department of Veterans Affairs to be the Office of Communications and Public Affairs, modifies the role of the office in regards to education benefits, veterans claims, veterans services specialists, and modifies several roles to conform to a communications focus, requires the office to manage the Maryland Veterans Service Animal Program and Fund. There's one sponsor amendment, which changes the name to Communications Outreach and Advocacy Program.
Senator Washington, seconds. Move the amendment. Is there a second to the amendment? I'll second the amendment. The reminder, this is Senator Klausmeier and Secretary Owings and Westmore and others who testified on this bill. Any comments, questions, debate? Seeing none. Senate Bill 654 is before us. Does anyone like to be recorded? Would anyone like to be recorded in the negative? Seeing none, Senate Bill 654 will go to the floor unanimous. Favorable with amendment. Next bill is Senate Bill 665, Senator Quarterman. And that's April.
Senate Bill 665, Natural Resources Healing, Hunting, and Fishing Fund, no-cost licenses and stamps. This bill establishes the recreational hunting or fishing opportunities that are provided using a grant awarded from the Healing, Hunting, and Fishing Fund may include providing at no cost, 1, an angler's license and trout stamp, 2, a Chesapeake Bay and coastal fish license, or 3, a hunting license and any corresponding stamps. There are no amendments.
The bill is before us, Senate Bill 665. There were no amendments. Is there any discussion? Seeing none, does anyone wish to be recorded in the negative on this bill? Seeing none, Senate Bill 665 goes to the floor unamended unanimously. Mr. Chair.
We're going to hold 687. Some people have an interest in this and see whether it's ready or not. Let's go to 695.
Okay. Senate Bill 695, Natural Resources Voluntary Firewood Treatment Certification Program Establishment. This bill establishes the Voluntary Firewood Treatment Certification Program in the Department of Natural Resources to certify forest product operators who export firewood to other states and use heat treatment and other procedures to prevent the presence of wood-boring pest infestations, wood-inhabiting pest, and plant disease pathogens in the firewood products. At least once annually and at any other time that DNR considers necessary, the department must inspect the facility and equipment used by a forest product operator certified under the bill. The department must keep a report of each inspection conducted. There are no amendments.
Moved and seconded. Discussion on 695. Discussion on 695. Seeing none, does anybody wish to be recorded in the negative? Seeing not, 695 will go to the floor unanimous 11-0. Okay, we're going to go back to a couple we skipped over, 492.
Senate Bill 492, environment, discharge permits, inspections, and administrative continuations. This bill establishes inspection requirements for the Department of the Environment with respect to permit holders under an administratively continued permit and those in significant noncompliance as specified, as well as reporting requirements and administrative penalty provisions for permittees operating in violation of specified laws and/or permit requirements. The bill also requires the department to assess the number of additional employees needed to clear the backlog of administratively continued permits and process discharge permits renewals in a timely manner, to report on its findings of this assessment. Finally, the bill requires the department to request position identification numbers or PINs for necessary staff as specified. There are amendments in your packet. Those amendments appear on the amendments appear starting on page 59. The reprint starts on page 63. Amendments do a couple of things. First of all, they strike language that would have prohibited discharge permits from being administratively continued after specified periods of time. So that's on page 64 of your voting packet. That language is struck. Delays the inspection of facilities found to be in significant noncompliance by 1 month if the facility or site is in noncompliance solely due to a failure to report. That's on page 65. Also delays in general the inspection of sites and facilities that are operating under these administratively continued permits until July 1st, 2023, and then provides that those inspections only have to occur once every 120 days, so that's once per quarter. Specifies that the department is not required to inspect operations of facilities or sites operating under a general permit that has been administratively continued unless the department or the U.S. Environmental Protection Agency has determined that the facility or site is in significant noncompliance as specified in the bill. So that's to get at things that are operating under, the state has a couple of general permits. The classic example is CAFOs, where rather than each of those facilities getting its own individual permit, the department creates one big permit that all of these facilities are under. So those would not be required to have quarterly inspections just because they were under an administratively continued permit. Finally, specifies that inspections are not required to be in-person inspections if the facility or site, if the presence of an inspector at the facility or site would result in unreasonable risk to health, safety, or welfare. So that would be to account for things like the spread of avian flu or other pathogens at a facility. Finally, the amendments alter some of the reporting requirements and moves up a certain reporting deadline. That's on page 67.
And there's a redraft, is there? Yeah,
Yes.
on 63. Let's put the bill before us and it's been moved. Is it moved and seconded? The amendments moved and seconded as well. These amendments came about after multiple conversations with MDE. We wanted to make it more palatable to them to enforce. Ms. Clark was in many of those conversations, who's in the back. People probably saw the front page of the Baltimore Sun today about the water permits and the number of inspections that have gone down and the violations that have gone up. It's an issue that we've heard since we had the briefing with the secretary. I'm not sure this is going to solve it, but I think it goes a long way to try to avoid the kind of problems we've had from the St. Mary's County with the contaminated oysters to Valley Protein to the super backlog, which the secretary actually wrote in a letter to me after our hearing saying they would get 90% of the backlog done by December 31st. We'll see. But this bill is a backstop to get them moving. It's not 100% of what was in the original bill, but I think it goes a long way. And while they don't sign off on anything, after 3 or 4 or 5 meetings, they were pretty close to saying we can live with 4 meetings. They're pretty close to saying we could live with it, although I don't want to put words in their mouth. So that's what the bill does. Discussion. Senator Riley and then Gallion.
Thank you, Mr. Chair. So this applies to any effluent or water treatment problems. Am I right about that? Including counties, municipalities, and the state? Oh, okay. The last part was on page 68 of the reprint. You talk about the PINs. I'm sorry, position identification numbers. It doesn't talk about how many. How will that number of personnel be determined?
Senator, that's a great question.
Well, thank you.
But it implicitly addresses the Department of the Environment. After our hearing, our briefing in January, we had a number of questions, and I had some follow-up questions, and I don't have the letter with me from the secretary.
It was not very inspiring.
Right, but the letter was very explicit. It said they will reduce the extended permits, the zombie permits, by 90% in the next 7 months. But nothing was said about needing 10 or 2 or 20 or 40 more pins. That's what was surprising to me. So on one hand, the letter said they're going to get rid of 90% of those in arrears, like 130. I think there were 190, so they were going to get it down to 20. So they were going to get 170 inspections and permits, and they didn't say anything about being short-staffed. When this bill was introduced and DLS contacted MDE, they, of course, said, we're going to need all these positions. So I'm not sure what to tell you. Now, we did amend the bill to take out general permits. And there are a lot of general permits, and we think that elevated the number of inspections. So in other words, a general permit is like, 1,000 chicken houses. So that was taken out in terms of these inspections every 30 days. And actually, they recommended inspections every 90 days, which we agreed to. So we want to get rid of the backlog. They said they'd get rid of 90% by December 22. We've actually given them to 25 or 26. So we suggest, and I asked the question, I'm sure you remember, did you make a request for more pins to the governor? And they said that's privileged information. So I think we asked for a report on their being short-staffed or how many pins they, this is a tough call. Is it because they've just ignored it or they really don't have the staff? That's an internal issue, and I don't have a simple answer.
This is a process question, if I can, Mr. Chairman.
Sure.
Like this, can a freestanding bill like this mandate pins? Or does it have to go through the budget process where the governor allocates and then it gets funded through the budget process?
Pins, we can mandate pins in a bill, but this bill actually does not mandate pins. What this bill says is that on or before October 1st, 2022, the department has to, so first they have to report on the number of employees necessary, and then they have to request the pins.
Thank you very much for the clarification. It helps if I read it.
I will also clarify, I got some math wrong in there, and it should say every 90 days for inspections and not every 120, because that would be quarterly, not 120.
So I think you kind of answered this with Senator Riley's line of questions, but I was just going back through the testimony from like Farm Bureau, and they had issues with the language that the significant noncompliance, that it wasn't really defined, and the issues, as you mentioned, with the CAFOs. So do these amendments kind of take away those concerns?
So the bill does not define significant noncompliance, and that, again, I think it was an intentional choice on the sponsor's part and out of discussions with the department. The only place I've seen that term defined is in some EPA policies, and even those policies reinforce that enforcement agencies have broad discretion in determining what rises to the level of significant noncompliance. That is a term of art. It is sort of well understood by the people at MDE that do this type of work, but it's not a specifically defined term anywhere. It's them using their best professional judgment, applying criteria that exist in EPA policy and state policy, but it's not a defined term.
So, for the sponsor, so the intention of this is to really go, the bad actors, it's not like for the minor, like little paperwork issues, correct?
We actually put in language about where there's a paper. One of the issues is, in many cases, this is self-reporting. So if you're doing a discharge, you've got to test your discharge. And a lot of companies or treatment places, they don't always do it, even though they're required to by the federal government. And the federal government tracks this. And they actually tell the state they have not gotten a report. We have put language in that said you can't be considered significantly non-compliant because of that. You have to be given 30 days. You have to let them know. You have to give them time to do their paperwork. Now, if after many months they say, I won't use the term, the heck with you, then they can come in. And again, this is mostly, these are permittees. So they're either, I don't know, give us some examples of who is discharging.
Certainly a wastewater treatment plant would be an example, but any industrial facility that has any sort of discharge.
Mr. Chair, in my district, we have a water treatment plant in a residential neighborhood that services 181 people. And after they go through the water treatment, the discharge that goes into the Severn has too much iron. So they're in violation of their permit. So it's a water treatment plant.
Discussion on the amendments. Seeing none, anybody object to adopting the amendments? Seeing none, the amendments are adopted. The bill is amended. Discussion. Would anybody like to be recorded in the negative? Seeing none, Senate Bill 492 will go to the floor unanimous. Let's do 221.
Senate Bill 221, Department of the Environment Enforcement Authority. This is it's an administration or a bill that was put in by request of the Office of the Attorney General. The bill updates, standardizes, and expands authorized penalty and enforcement actions that can be taken to enforce several provisions of the Environment Article governing the appropriation or use of waters, reservoirs and dams, non-tidal wetlands, water pollution control, drinking water, water quality laboratories, waterworks and waste system operators, and wetlands and riparian rights. Generally, the bill authorizes or augments civil, administrative, and/or injunctive remedies. The bill also establishes new reporting requirements for drinking water and wastewater facilities and establishes a definition of person under Title 12, Waterworks and Waste System Operators. There are some amendments in your packet. The first amendment appears, the amendment itself is on page 3, but there's a reprint that follows starting on page 5. This is being offered by Senator Corrosive, but I believe it's by request of MACO. So the amendments would prohibit penalties from being imposed on individuals under the waterworks and waste system operator provisions of law unless the individual acted with actual malice. You can see where that language is on page 27 of the voting packet. The amendment would also alter the definition of person for purposes of those provisions, essentially to exclude individuals. That language is on page 22, the voting packet. And finally, the amendment would restore the willfulness requirement to the provisions of law dealing with drinking water violations. And that is on page... Apologies. It's on page 10 of the bill, so that's on page 14 of the voting packet. Striking brackets. I will just note that these amendments have been run by the Office of the Attorney General, and they do have concerns about them.
Is there another set of amendments?
Yes, so there's another set of amendments, so those, sorry, that's the Senator Corrosive amendments. There's also amendments from Senator Hester. Those start on page, the amendments themselves are on page 32, the reprint starts on page 33. These amendments strike the authority to impose administrative penalties and instead require MDE to petition a court to impose a penalty, which is essentially a civil penalty, which they do already have the authority to do, and provides that penalties only become a lien in favor of the state if the violator fails to pay the penalty after a court order, and the penalties is recorded in the land records. Again, the Attorney General has some concerns about that because these are not in rem proceedings, so typically a lien would not be filed in the land records, it would just be filed with the court. And then there's one more amendment from Senator Hester, is that, sorry, help spreading around. So this one would add language requiring the department to notify the Attorney General each time the department initiates an action for an administrative penalty for a violation of any provision of the environment article or any rule, regulation, order, or permit adopted or issued under the article.
Okay. Let's first put the bill before us. It's been moved, it's been seconded. Let's start with the Corrosive Amendment, the first one you described. The Senator?
I did work with MACO on the amendments offered by MACO. The first one, the purpose is to protect our wastewater employees from being held liable for violations under this legislation unless it can be proven that they acted with actual malice. As you all know, it's already very difficult to attract and retain personnel to operate at these wastewater facilities. So by opening the personal liability of employees, it will make recruitment and retention even more challenging. The amendments also retain willfulness as a criterion for determining if a penalty should be levied on a county. Again, this is important when circumstances are out of control of local governments. And again, I think it's to provide some, protection here for our counties. So that's why putting in the specific willfulness was important in these amendments. So I would move these amendments.
By where the Corrosive Amendment was in our reprint?
I think the operable issues are on page 25 and 27. That's the middle of the reprint.
Page 3 and 4, though, is the amendment. Right at the beginning.
Right, but if you want to see it in context, 25 redefines individual, and 27 says an individual may not be held liable. And then there's obviously where malice was inserted, and I'm not sure where that was. April, where's malice?
So that's on page, malice is, yeah, page 26 and 27. I do just want to flag that, I mean, the definition here of individual, it's broader than necessarily an employee. An individual means an individual, a receiver, a trustee, a guardian, an executor, an administrator, a fiduciary, or representative of any kind. You know,
Yeah, let me speak that if I could. You know, about an hour ago, Senator Ellis, you raised a question about liability on that hunting bill. When I look at this list of the definition on 25, the operator, the superintendent, the executor, I mean, I don't know who's left. And not only that, they have to be willful. I mean, I think that's pretty high, you know, standard. It's not even disregard or competence. My view, if we adopt this amendment, this bill doesn't do anything. And we have had a lot of drinking water problems. We've had a lot of enforcement problems. And I think the reason the Attorney General submitted this was to say, we got to get a handle on this. And I think this totally undermines what he was suggesting we do. So I would urge a no vote on this amendment. I think it just undercuts, and it's really MACO's just trying to protect themselves from suits, and I think that's been one of the problems. I think I saw Senator Hester, then I saw Senator Riley.
Thank you, Mr. Chair. I was just trying to understand who would normally, like, be served. Is it normally the person, or if it's if you work for a municipality versus like if you work for a company? Isn't it usually the entity that is served or sued?
what the violation is, right? So it depends what the violation is. If the violation is something that the company is doing, but my understanding is that this particular subtitle goes further than just, the actions being taken by the company. It's also things like the responsibility of an individual to have specified certifications in order to perform certain works. It's not all, so the bill as it came in is drafted broadly, but the intent, my understanding is the way it would operate is that it's always a question of, who's actually liable under the law before they would be going after anybody for a penalty.
We spoke earlier about the definition of person, and that's like on 17, 18, 19. So when we talk about a person here, is this an individual or is this the entity?
So as the bill was originally drafted, it could be either. And that's how our law typically works, is person is a broad term that can mean an entity or an individual. So again, just depending on the circumstances, the violation, what action that they're pursuing.
So is your understanding of the attorney's, the Attorney General's intent to be able to use this for either an individual or an entity?
Yes.
Okay, thank you very much.
Senator Riley.
Thank you, Mr. Chairman. Just, got these amendments just recently. On three pieces in the bill, it talks about a lien in favor of the state on any property and recorded in the office of the clerk of the court. Ms. Morton, the recorded in the office of the clerk of the court is putting on the land record that there is a outstanding lien. It's an official lien in the property records. Am I correct with that?
Are you on Senator Carrozza's amendments,
the-
or are you on Senator Hester's amendments?
I'm on bottom of the page 12, bottom of the page 20, bottom of the page 27, bottom of the, or top of the page, unnumbered 26 to 26. So this wording appears 3 different times. So first of all, I need to know the intent, and then I need to know why we've listed it 3 times.
So, because, so that's standard boilerplate language that is used everywhere in the environment article when an administrative penalty is authorized. And because this is creating 3 new sections where the Attorney General is authorized to use an administrative penalty. So an administrative penalty, right, is a process that is handled through an administrative hearing process before an administrative law judge. It's not handled through the courts.
Okay.
And then, so when they come up with the penalty, it gets registered, it's not recorded in the land because it's not an in rem proceeding, it's in personam, it's against the person, not against the land. So it gets recorded in the court, not in the land records.
Okay. So, Mr. Chair, the question that I brings up is we have a facility. Somebody wants to sell it to another operator. The new people who are buying it want to make sure there's not encumbered in any way. And when they go to the land records, this administrative fine is not recorded anywhere. Could that prove to be problematic when we do property transfers?
I'll defer to the attorney.
Yeah.
I don't know the answer to that.
Yeah. When I read it, it appeared that it was being entered into the property records, but again, I'm not an attorney. I don't even play one.
We all do.
I understand.
I just don't, the short answer is I don't know.
All right. And it's problematic. It appears 3 different places. I think we need a.
I mean, it also.
If the clarification is, that's the way it's always done, always been done, always will be done, I guess that's one issue. If it can be fixed, I think that'd be a second discussion. Thank you, Mr. Chairman.
Okay, we have the Corrosive Amendments. Mako wants it, I feel, drastically weakens the bill and sets willful as a standard we'll never approve. So let's do a roll call on the Corrosive Amendment, and then we'll move on to the others.
Senator Kagan? No. Senator Kagan, no. Senator Lamb? No. Senator Lamb, no. Senator Hester? No. Senator Hester, no. Senator Ellis? No. Senator Ellis, no. Senator Gallion? Yes. Senator Gallion, yes. Senator Carrozza? Yes. Senator Carrozza, yes. Senator Washington? No. Senator Washington, no. Senator Riley? Yes. Senator Riley, yes. Senator Patterson? I'm sorry? No. Senator Patterson, no. Senator Salmonair? Yes. Senator Salmonair, yes. Senator Penske? No. Senator Penske, no. 4-7.
The motion is defeated 7-4. Let's go to the next amendment. I think it's, Senator Hester has 2 amendments. Senator, which one do you want to proffer first?
We can go with the first one that April introduced that's in the packet.
Okay.
So this speaks directly.
Let's get there first.
Yeah.
The reprint is on, the amendments on 31 and 32. It starts with a reprint on 33. Senator?
Thank you. So this amendment is attempting to clarify what Senator Riley was just talking about. It was brought to me by the Real Estate Property Association and the bankers who deal with real estate. I understand that there may be some concerns, but I'm confused enough to offer the amendment and engage in a conversation. So the way I understand the amendment is that it was intended to be procedural in nature. It was recommended by the practicing real estate attorneys of the Maryland State Bar Association's Legislative Committee, and their written testimony should be in the bill file. The amendments seek to clarify the penalty provisions of the bill to be consistent with the existing role of the judicial process. And so the First Amendment clarifies that MDE may petition a court to impose a penalty for a violation of the bill. And then if a person fails to pay a penalty after an order of the court, a lien occurs in the state's benefit when it's recorded in the county land records where the property is located. And I do believe we have somebody here to answer questions.
And I wish somebody from the AG's office were here, but,
Is anybody from the AG's office in attendance? No. Okay.
so I'm just gonna read the email that they sent me.
That's fine.
So they said, and I agree on this part, because it requires it says, if you look page 35, the department may petition a court to impose a penalty for a violation. That's a civil penalty. They already have the authority to do civil penalties. The whole purpose of the bill is to give them an administrative penalty authority, which would not be before a court. It would be an administrative hearing before an administrative law judge, who then determines the penalty. That can be appealed to a court, but it's not a civil proceeding. It's an administrative proceeding. So the AG wrote this amendments eliminate all administrative penalties, even where they already exist, by making reference to petitioning a court in a court order. When it discusses the department assessing a penalty or issuing an order, that is an administrative proceeding. In the administrative actions, the matter is heard at the Office of Administrative Hearings and can be appealed to a circuit court. By the amendments adding references to a court, the amendment makes it no longer an administrative action and creates two civil penalty provisions that contradict each other. The lien is also not recorded in land records because this is not an in rem proceeding. It is an in personam proceeding, which is against a person and not the property, and the lien is filed with the court for such debts.
So on the first point, just, we can break them up. They can already petition the court and go to court. The Attorney General has, because there have been so many violations, they want to be able to initiate administrative complaints. This undoes that, the first part. Is that correct?
I mean, I read to you what I thought the amendment was trying to do. I really truly don't understand how I got from my original intent to what has actually happened as you explain it.
Well, if you look on page 35, line 7, 8, the original language said the department may, not shall, may impose a penalty for violation of any provision, so they do it under administrative procedures. By adding the word petition a court to impose a penalty, it obviates the administrative pathway. Is that correct?
Yes.
I think Senator Riley might be able to help me.
I'd like to ask an appropriate question. If I may. Thanks. And thank you for those two terms. In Ray, you said? REM.
Proceeding against the property versus a proceeding against the person.
Okay, so what you're saying is, if a lien is established by an administrative court, it's against me, not my property. I'm the operator of the, if I'm included as a interested party who has control of the operation, and I violate these procedures, I get a $10,000 fine, and it, therefore a lien is against me, not the facility. So it's not a real estate.
But against, it's against a person, so it's against the suit would be against, XYZ power plant or
Right.
whatever.
Or Anne Arundel County, or.
Sure, but what it means is that, it becomes a lien on the property of the person. I'm not explaining this well, I'm sorry.
That's okay. Anyway, if it's a lien on the property and it's not recorded, that's problematic for me. But I already told you that.
Wait, Senator, just so I understand, so you think it should be on the property? You said it's problematic for you. I'm trying to understand your concern.
What I'm advocating is, if it's a lien on the property, we got to list it as such. If it's a lien against the operator or any of those other terms that we have in the bill, that's fine, because then I could walk away from the property and still be personally responsible. So if it's against me, it's fine. If it's against the property, and I want to go borrow money to improve it, the lending institution should know that there's an outstanding lien.
I think the difference is that I'm not sure the lien follows the property. Let me look into this a little bit more. It's because there's different types of actions. You have, yeah, let me look into this a little more.
Let's do this. Let's first, we'll give council time to look, and we'll come back with some other bills we're going to do. But I'd like to split your amendment and take up the first part, if you want to. I mean, the question of 35, moving it back to just judicial and remove their ability to do administrative, I don't happen to like personally, but I'd like to, there are different concepts here, so I'd like to take each one up separately.
That would be fine. Should we have the EHE?
Let me get through this. Okay, so let's first take up the amendment on 35, which separate, we're going to hold on the lien issue for now. The interpretation from the council is, in fact, it reverses the efforts to have administrative procedures. So that's the amendment before us. Discussion on that, Senator Washington, then Vice Chair.
So, again, I appreciate always efforts to make things better, but I've experienced having certain entities rewrite the bill so that it's not effective at all, and they use really nice language. But yeah, it does, we don't want to, it sounds like it's a good to be able to have an administrative hearing outside, you know, other than a civil hearing. So there's a lower level thing that can happen before somebody is charged. So I would have to, vote against the amendment that would remove the ability to not only have administrative hearings in this case, but it seems like unintentionally it removes all other administrative hearings, and I'm sure you don't want to do that.
I just was going to clarify before we all voted that this is the 4 words that we are voting on, petition A Court 2, which it feels like it takes a tool out of the Attorney General's toolbox, so I'll be voting against the amendment.
Thank you. Well, I think Senator Washington said it very well, and I appreciate your offer to split the amendment because, as I stated, the first part wasn't my intent, but the second part I think there needs to be clarification on. So I would either withdraw the first part of the amendment or I would vote against it, whatever is the chair's preference.
Drawn, let's skip the whatever. Let's go to your other amendment, Senator. I think that's a freestanding amendment. We might get clarification on the lien issue. So why don't you take a minute to tell us what that does and the purpose?
Thank you very much, Mr. Chair. So you may recall, I don't know, it feels like ages ago, we had a really long amendment that was offered by one of the environmental organizations, and I think that one was probably fairly drafted. Working with April, she's helped me to craft this one that simply states the department shall notify the Attorney General each time the department initiates an action for an administrative penalty for a violation of a provision of the article or any rule, regulation, order, permit adopted or issued under this article. And the point here is that there are tons of administrative proceedings, and we only get the ones that rise up to the higher level. And so this would create, a more awareness, and then perhaps the Attorney General's office would be able to investigate some that they deem should actually be looked at, but they don't know what they don't know at this point in time.
I have a question, and again, you probably have more knowledge of this. When it says the department initiates an action for administrative penalty, isn't that done through their assistant attorney general assigned? And isn't that exactly what we're talking about? I'm trying to understand the import of this, that's all. I mean, don't they know it? If they're pursuing administrative penalty, doesn't by its very nature the Attorney General's office get notified? Because they are initiating the action, their Assistant Attorney General?
I mean, so it would be their Assistant Attorney General who would be involved in any enforcement actions, but this would be a additional step of notifying the Attorney General. I don't know.
Okay, I'm just trying to understand it. Okay. Discussion on the freestanding amendment, the 4 lines. Senator Simon Ayer.
Yeah, I mean, I don't think we should be creating duplicative process if the Assistant Attorney General has it in the department and assuming they're communicating in the same department. And then one of your statements you said up front is they have tons of these. And I think your amendment says each time they're to notify them, so they're going to be notifying them tons of times. Just seems a little overkill. Just my thought on that.
I should have been more precise in my words. I mean, I believe, and I'm sorry, I'm sure we're all tired at this point in session, that there were like maybe like a dozen or something that rose to the level where the AG was actually involved, and there might have been, hundreds of these other ones that nobody really, that are not tracked. So when I made the amendment, it was not my understanding that it was the department's assistant attorney general that was doing the administrative penalties. So, I mean, it sounds like council has now clarified that that is indeed for all of the administrative penalties.
I think the concern of the groups that were originally kind of pushing this question is, it's really the, what gets raised to the level of having a more formal procedure, which might involve bringing in counsel, I think, from outside the agency. But if they're pursuing an administrative penalty, it's going to be their enforcement people are all assistant attorney generals. But they're embedded in the department, so they're still sort of under the office of the attorney general, but they work for two masters. They sort of work for the secretary and the AG.
Senator, again, I'm not an expert on this, far from it. I thought the sense I was getting, there were too few actions. They had to go to court, and, I'm sorry. And my understanding, and again, it could be misinformation or little information, there were too few actions being taken by the department on whether it's drinking water, discharge, whatever, and they weren't pursuing them. They chose not to go to court, and they want to make it a little easier by going through the administrative process. So I don't know if the concern was there too many of these. I think from what I've heard from the Attorney General is there's too little enforcement, and they wanted their Assistant Attorney General assigned to the agency to be able to have some pathways that were more efficient. So maybe there would be more prosecution and getting people to clean up the water or discharge or whatever it might be.
For what it's worth, the Office of the Attorney General is not opposed to this amendment, so including a notice requirement.
Okay. Yeah, I don't care. That's fine. Okay. Any objection? Okay. The amendment passes 9-1. Okay, you need more time on the lien?
I just, as somebody who does not practice in this area, I'll just be blunt, I don't fully understand it. All I can say is that that language is identical to the language that appears throughout the environment article establishing administrative procedures, so I just, aside from that, I can't, I'm trying to get an answer, but I haven't been able to so far.
Well, it's well, let's move on to knock out a few other bills. We'll see if we can get something. We understand they're listening, but they're not necessarily being responsive. And so if you are listening, someone in the Attorney General's office, we would like clarification on this lien question, whether it's on the entity or the property, and whether it gets recorded in land records. Okay. Hold for now. We're going to come back to it hopefully in the next half hour, 45 minutes. I'd like to clear out what we have here. Okay. So let's go to 705. Senator Zucker.
Senate Bill 705, Education, Physical Restraint and Seclusion, Limitations, Reporting, and Training. This bill prohibits specified public agencies and non-public schools with specified exemptions from using seclusion as a behavioral health intervention for a student. The bill prohibits, with exceptions, a public agency or non-public school from using physical restraint on a student as a behavioral health intervention. Before using seclusion as a behavioral health intervention for a student in a non-public school, a healthcare practitioner must possess specified credentials, have received relevant training, and be clinically familiar with the student. If a student in a public school or placed in a non-public school by a local school system is physically restrained 10 or more times in a school year, the school must notify the local school system and the Maryland State Department of Education at the earliest opportunity. If a student enrolled in a public agency that is not a public school is physically restrained 10 or more times in a school year, the public agency must notify the department at the earliest opportunity. There is one amendment from the sponsor, Senator Zucker, starting on page 82 of your packet. There is a reprint on page 84. What this amendment does is strikes the definition of physical restraint and substitutes the definition that is currently in departmental regulations. It exempts the Juvenile Services Education Program from the provisions prohibiting public agencies from using seclusion and limits on physical restraint, corrects a drafting error, and requires a public agency and its local school system or a non-public school to submit a systemic, evidence-based correction plan to the department if the public agency or non-public school fails to comply with any provision of this subtitle or reports that a student has been physically restrained or placed in seclusion 10 times or more in a school year.
Yeah, let's get it in front of us so we're talking. It's been moved, it's been seconded, Vice Chair.
Quick question, and forgive me, I'm not sure exactly. You said must notify as soon as is practicable or as soon as possible. Is that clear enough, and could that be 3 weeks?
It's not limited, assuming that they have, as soon as staff is available to make the notice, they should make the notice.
So this committee passed a bill, and I realize that it's a totally different area, but we passed an election bill. Senator Lamb had language, and we adopted it on as soon as practicable and not later than 2 business days or something of that ilk. It seems like there ought to be some time limitation, because I think the information should be shared in a timely manner.
What page is that on?
It is on page, let's see here, I think it's on page 90. Let's see here. Wait. hold on, I'm looking. Oh, I'm sorry, it's on page 88. You're looking on page 88 in lines 24 and 25 and 29 and 30.
So may I propose what may or may not be a friendly amendment to the amendment?
Door's open.
Um,
I mean,
I-
we actually haven't moved the amendments, but.
I'll move the amendment.
Okay, so, the Zucker amendments are in front of us, and the vice chair would like to amend the Zucker amendments.
So colleagues, I think if there's a child who's being restrained 10 or more times in a school year, I think the department should know about it, and I think at the earliest opportunity is really too flimsy for my preference. So whether that's 2 business days, or whether you say 2 school days, if there's a holiday or what's reasonable, Stacy? And is there anything else? Is there any
Well,
precedent in
there's something to
code?
consider in that this language, again, it begins with who is restrained 10 or more times in a school year. So there's no definite date here. I mean, they can hit 10, but, I mean, the problem here is that the bill now defines how a seclusion has to be determined. For example, when a child gets put into a room and the child is prevented from leaving by any means, that is considered one seclusion. If they open the door and the child can come out and the incident starts again, that becomes the second seclusion. So, I mean, there's now a system for determining how that happens. So I think the reason it was left open like that is because, again, I mean, how are the entity, the public school or the public agency, do they get dinged if it's the 10th time and they don't do it right away? Or, I mean, I think the earliest convenience is, they're sitting down, they're going over the paperwork, and they've determined, oh, this child has had it in this many times. I don't know personally how, when they're looking at the case record for a particular student and saying, okay, this child has had this many incidents, and therefore now we have to report. If the paperwork isn't reviewed for another 2 weeks, how do you determine? I think that is why, in this instance, there's no clear specific number of dates, because it's a little bit more open.
So I'm going to pursue this further. I don't think that's okay. I think waiting 2 weeks to do paperwork, if you are restraining a child more than 10 times, is unacceptable. So again, I'll defer to, Senator Washington, do you have ideas? Does anyone, I see some eyeballs. I'd love to put a date. Earliest opportunity is fine, and not later than, and not longer than, blah, blah, blah. What seems like a good number to someone else?
So you were saying that 2 weeks is too long?
I think so. If
So-
you found out that your child was restrained more than 10 times, I would think that the department ought to know about it. I think you'd want to know about it, for
Yeah.
sure.
So, I mean, if you've approached 5 times, could you send a warning within 5 days to the parent? If it's happening up to 10 times,
Right, so this is to the school system, to notice to the school notifying the department, and then, and the same thing would apply for a non-public school. So it's the same language on page 88 for both public and non-public.
yeah. So, probably, 2 business days, that'd be good. Yeah.
Colleagues, I don't know what you think. I defer. I think that seems reasonable after 10 times.
Senator Patterson?
I support the idea of being a little bit more specific if we possibly can, because I'm not sure that would even stand up in a court of law if you were to go there. You're going to have some measurable time in writing to say you should have gotten this done within 20 days, 21 days. I think I could live with 14 days, but I would hate to think that someone had had my child incarcerated or whatever for more than 14 days, but it seemed to me something else should trigger before that full 10-day period is up. I wouldn't wait 14 days. I mean, I'd probably be out there the next day. But now how we want to say it here, I don't know. But I do think just leaving it open without a specific date is too haphazardous. I would like to see a date.
Okay, let's try to resolve this, folks. You know, I would think when restraints used, the parents notified, but I guess that's, I don't see it in this bill, but I assume in local policy, special education policy, I can't believe it's after 10 times the parent is finally notified. Again, that's separate from the issue of after the 10th incident, telling the department. I mean, obviously, it's a major problem. And again, they can only do restraint under certain circumstances earlier in this bill. I mean, there are only certain situations they're allowed to do it in.
Which seclusion can only be used by a non-public school. It cannot be used by a public agency under this bill. It is prohibited outright. The only time seclusion can be used is in a non-public school under these specified circumstances. Parents are notified in a different provision. This does not apply. There's nothing in this bill that talks about when the parent is notified. This is talking to the department after a certain period of time when that threshold has been reached. If you're going to put in a date, you have to have from a period of time on which it is discovered. What I'm saying is that I assume is that when you have an incident, maybe the incident only happens once, it's in their folder, or in their record, and then another incident happens, maybe it's 30 days from then that it happens. So, I mean, what you're saying is you want it in time, but the question is, when does the non-public school determine at what point they've reached 10? You're saying after they've discovered it? And what happens if they don't discover they've hit 10 until like a month after when they're reviewing a file or at an IEP meeting? Or that's the point I'm trying to make here, is that there could be a huge amount of time between each seclusion incident and you may not hit. So they may not discover it's 10 until they're doing a longer look at a case file.
So I don't know if that distinction between notifying a parent, because you're saying the bill doesn't address that, or it does address that, versus notifying a school system, that, right? So it's not as, so we're notifying a school, so we're notifying the school system, so it's not, not notifying a parent. So I think, 10 days or something, that's not really a long time, because I guess the expectation is that you're creating a pattern of behavior for a particular school, so that the superintendent has to come in and take a look at that school. That's the intent, is to provide a management tool for the LEA.
Right, I think that's important, and I'll defer to you, Vice Chair, in a moment. This section is notifying the State Department and the central office of the school system. The principal, and I think somewhere else in the code, the parent has already known about this. This is to see in a macro view if there's a major pattern going on. I think Senator Washington's right. But, I mean, let's not belabor this. Let's come up with a solution and move on. I know people are getting a little fuzzy.
Attended, well, 5 then. So it's not as urgent. I'm saying I don't feel the urgency as much, since this isn't about notifying a parent about an incident. This is an administrative thing. And the idea of them collecting data every couple of days and entering it in, I do think that that's administratively difficult. But to go from not doing anything at all to so
I agree
was
with
okay
the
with
chair. I don't think we want to take forever talking about this, but it seems to me, and I heard what Ms. Goodman said, I understand, and that, yes, there could be 30 days, but she also said it could be 2 hours or part of the same incident or whatever. So it just seems to me if there's a student that's challenging enough for a school, that a principal, administrator, a teacher, people are paying attention to it. Because little Johnny or little Susie or whatever, you know, once, twice, 3 times, okay, 4 times we're having challenges, 5 times, 6 times. By the time you get to 10, people should be paying attention to this child, to the teacher, to the staff, and why there are so many issues. And I think the department should have that data in a timely manner. So, again, I defer to colleagues.
If we want to put a date certain, let's do, Senator Washington mentioned 2 weeks. You know, it's to do the central office and the State Department. The school clearly knows, the team, special ed team knows about this child, the parent knows about it. Anyway, I don't, you know, just make a suggestion.
What you don't want, I think if you ask it too regular and it's too much, they'll just underreport. So there's this tension. I would allow there to be time. So it could be 10 business days or no more than, but we're going from nothing to something. And so maybe we can, you know, go ahead. Okay, well, all right.
After the 10th time, earliest opportunity, you keep that language, and not longer than 4 school days.
Okay, how many people, if you support making this 4-day reporting, signify by raising your hand. 3, 4, I'm sorry, keep them up. 3, 4, 5, 6, those opposed. Okay, 6 to 3, it passes. Okay. Other discussion on the Zucker amendments? Other discussion on the Zucker amendments?
So where was how often are parents notified?
That's-
You said that was a
that's
separate
already addressed
section.
somewhere else. He doesn't deal with it.
Okay, thank you.
This removes seclusion and allows restraint under certain circumstances only, and then it has the procedures to do if they want to use restraint or complaints, I think. I don't want to homogenize it, but that's Senator Washington.
I guess I have a question. Mansef was good with the bill, and they have a amendment about adding licensed behavioral analysts to Section D on page 5. Is that in the amendments? I just want to know if that.
It was not included. Senator Zucker considered this amendment and rejected it because he said, according to the stakeholders, licensed behavioral analysts have students who are, students under their supervision get secluded and physically
Okay.
restrained more often than other of the health practitioners listed in the bill.
Any objection to adopting the Zucker amendments as amended? Seeing none, they're adopted. The bill is amended. Discussion on 705. Anybody like to be reported in the opposition to the favorable? Seeing none, 705 is adopted. Okay, let's go to 978.
Senate Bill 978, Garrett County Memorial Hospital lease authorization and alterations to Board of Governors. This emergency bill authorizes the county commissioners of Garrett County and the Board of Governors of the Garrett County Memorial Hospital to lease the Garrett County Memorial Hospital. If leased, the Board of Governors shall be reduced from 9 members to 3 members, with 1 member appointed by the county commissioner, and establishes meetings, membership selection procedures, removal, and vacancy in the event the hospital is leased. There is a technical sponsor amendment that conforms the bill language through the Garrett County Code to the actual updated Garrett County Code.
Garrett County Hospital, discussion. It's been moved, it's been seconded. Further discussion? 978. Sure.
So, Ms. Foxworth, so one, if the hospital is leased, then it's reduced to 3 board members. You said 1 is appointed by the county commissioners.
Right.
So How about the other two?
So the county commissioners get to decide how the other ones are selected through meetings, not necessarily through regulations, but they'll determine the specifications for them.
So technically, they will decide how all three are.
Yeah,
appointed.
essentially. There was a clear distinction. Let me see.
No, she's checking to see.
So the actual one county commissioner has to be appointed, and then the actual county commissioners as a whole have to adopt those procedures. So it's not as specific for the other two, but they may be appointed, but they may not be.
So you're saying one board member would be a commissioner?
So the one board member is appointed by the county commissioner.
Okay.
Then the others, the county commissioners have to adopt additional regulations for them in a broader way. Than not necessarily appointed.
Yeah. Okay.
Hey, on 978, with the Edwards amendment. Any objection to adopting the amendment? Seeing none. The bill as amended. Anybody wish to be recorded in the negative? Seeing none, it'll be sent to the floor 11-0. Okay. We're going to go to your list number 23. Um, 437.
Senate Bill 437, Agriculture, University of Maryland Extension Urban Farmer Assistance Program. This bill requires the University of Maryland to hire, one, an extension agent dedicated to urban farm production methods and crop management, and two, an extension agent dedicated to urban farm and agribusiness management. Each extension agent must perform applied research and provide education for urban farmers as specified. Beginning in fiscal 2024, the governor must include an appropriation of $300,000 in the annual budget bill for the University of Maryland Extension to the agents hired under the bill.
Is there a second? Second by Senator Ellis. Discussion on 437. Anybody wish to be recorded in the negative? And we did get approval on the money from budget and tax on that. Okay, that's passed on that bill? Okay, well, okay.
April, if it's not too late, I'd like to be added as a co-sponsor.
All right, so that changes the motion to favorable with amendments. That's fine. That's okay.
Okay. Anybody else want to jump on? Okay. Favorable with amendment. Okay, let's go to 438.
Senate Bill 438, Young Readers Programs Establishment, Young Readers Program Expansion Act. This bill establishes the Baltimore City Young Readers Program in the Governor's Office of Crime Prevention, Youth, and Victim Services. The purpose of the program is to work with the Dolly Parton's Imagination Library to mail free, high-quality books to children in Baltimore City. The bill also establishes the Young Readers Matching Grant Program to provide matching grants to counties that support the establishment and operation of an affiliated service. For each fiscal year, the governor must include in the annual budget bill an appropriation of $200,000 for the Baltimore City Young Readers Program and $500,000 for the Young Readers Matching Grant Program. There is one amendment from the bill's sponsor, Senator McCray, right behind that voting list packet there. What this does is it strikes the specific mention to the Dolly Parton's Imagination Library and substitutes an early reader organization, meaning a nonprofit organization. It also strikes the $500,000 appropriation and brings that down to $250,000 for the statewide program.
Okay, is there a motion on the bill?
Quick question before motion.
Sure.
Ms. Goodman, could you just clarify, we passed something very, very similar for Charles County that was sponsored by Senator Ellis. Is this identical or close?
It is
or
not
how different?
identical because that bill, it was a certain amount per child who registered in the program, and it was through the library. This is like a fund, and then there's an appropriation amount for Baltimore City specifically and a statewide too.
So I just wonder, sometimes when we do something a first time, like agritourism, then we come back and back and back, and everybody wants to kind of be in. I just wonder whether the Ellis model or this proposed McCray model would be better if we were to start seeing more and more counties coming in. Is there a policy or fiscal sort of wisdom that we should be reflecting on?
That's a policy question for this committee to answer.
Yeah, I would suggest, we have this bill in front of us, crossovers coming up. If we get more next year with the first one that comes in, we'll deal with it.
Okay.
So let's put the bill before us.
Favorable.
Moved, seconded. The McCray amendments, any objection to adopting them? I feel bad, they're taking Dolly out of it. She's got a new book and a new album, apparently. She's co-authoring with James Patterson. Is that a pair?
James North.
Huh?
Yeah, right.
Any,
If only.
and it also cuts the amount in half, and we did get approval from Budget and Tax. Any objection to adopting the amendments? Seeing none, they're adopted. The bill as amended is before us. 438 as amended. Would anybody like to be recorded in the negative? Seeing none, that'll go 11-0. This one, the next bill did not get approval for a fairly expensive program, so we can either sit on it or kill it.
698.
698. It's like $1 million, I think, and
Suckers taking care of our capital budget, let's sit on it.
then there is a hold on 698.
A permanent hold. Special order until April 1.
Okay, 818. Ian, can you help, please? We're almost there, folks, almost there.
All right, Senate Bill 818, Environment Permit Applications, Environmental Justice Screening. This bill requires a person who is applying for a permit issued under the Environment article to include the EJ score from the Maryland EJ Screen mapping tool for the address where the applicant is seeking a permit, and the Maryland Department of the Environment to conduct an analysis in accordance with regulations adopted under the bill of the address where the applicant is seeking the permit using the Maryland EJ Screen mapping tool. MDE must conduct the required analysis prior to deciding whether to issue a permit. Bill requires MDE to adopt implementing regulations by October 1st, 2023. There are amendments in your packet, in the sort of slimmer packet. The amendments, first of all, they just require the department to use the tool to verify the applicant's information and provide a description of the environmental justice indicators contributing to the EJ score of the address where the applicant is seeking a permit. I believe these were to sort of respond to the concerns of the Department of the Environment that were thinking that weren't quite sure what analysis meant. I also just passed around something that the Department of the Environment sent me today, which they said these are amendments that they've sort of worked out with the House. So this is sort of for information purposes. Would, instead of saying specifically the Maryland EJ screen, it calls it the Maryland EJ tool. Also, instead of talking about looking up, applying the screening tool to particular address, talks about application to a census tract, which I think is sort of clarifying that's basically how this tool works right now. Also specifically specifies, this is on page 3, that the applicant would either have to use the Maryland EJ screen mapping tool, or unless the permit requires the applicant to utilize a United States Environmental Protection Agency developed tool. So that's to deal with cases where federal requirements actually might require the use of a different tool. And then the final kind of big change in the MDE's proposed amendments would, instead of requiring the department to sort of do this analysis, would shift that burden onto the permit applicant, and would just have the department reviewing that analysis.
Okay. So this is with the amendment
Those are the amendments
plus.
plus MDE's proposals.
Okay, let's get the bill in front of us first. Senator Ellis moves, Vice Chair seconds, or Senator Hester seconds. Senator, let me suggest we combine, who did the first set of amendments?
Senator Ellis.
Senator, if you don't object, can we combine your amendments and MDE's amendments? Yeah, I think what the senator's amendments do in MDE, it makes it not a review, do a full analysis, but using this tool, and it brings down, I have to tell you, the fiscal note. Because when it was first read, it was like this hyper kind of situation where they had to have consultants do with every agency and every action. I think this language brings that down, and I think based on that, B&T said if it takes to 200 or 500,000, whatever it was, they will approve it. And I think it's a good tool. Obviously, we included some of this language in the climate bill we passed last night. So if there's no objection, the freestanding 4-page sheet is a combination of Senator Ellis and the MDE recommendations and the objection to adopting those amendments.
We'll just note, just for transparency's sake, that they also take out the deadline for adopting regulations. So that's on page 3, the reprint.
What did it have?
So it had said the regulations had to be adopted by October 1st, 2023. So they've struck the deadline.
Well, let me ask this. I mean, not every bill needs regulations. It says they may adopt regulations. Sometimes a bill is explicit enough, they don't need to do regulations. I mean, I don't know why they took the date out and it said they may adopt regulations. I mean, you don't want to force them to do regulations if the bill is clear enough. So, but I'm agnostic on that amendment.
I just wanted to flag it because I hadn't mentioned it when I went through it before.
No, that's fair. Anyway, Senator.
But could we maybe sunset it to force it to come back next year? No, this Ellis bill, if he doesn't, I'll let him call the shot. If he happy with it, fine.
I mean, I guess we could say, if regulations are needed, they shall be completed by. I mean, giving them 17 months is more than enough goddamn time. I don't care. I mean, if we want to have it just like with the House and it's done, or we can put an amendment in, it's your call.
So without, question for Ms. Morton. So without that deadline, can the department just ignore this bill and not require the screen?
No, I mean, I would say no, because it says that a person applying for a permit has to use this tool and submit this information with a permit application. That part's not dependent on whether or not the department has adopted regulations, so.
So, yeah, I would think we could leave it out then.
Okay. So then the combined amendment, MDE and Senator Ellis, no objection, adopted. The bill as amended, discussion. Senator Gallion.
So I was just rereading back through this. So the purpose of this, you use this tool and you get a score. How will that affect future development? I was looking at the realtors. I mean, what's the ultimate goal? What will this bill do? I mean, you get this score, then what happens? What's the payoff here?
So under the bill as it is, even as it came in and as amended, it does not require the department to take any particular action based off of that information. It's purely, it's part of what the department has to release when they do public notice about the permit application. So it's just, it becomes part of the information that is available to the public.
And that's available, remind me, how's that available again? If a local jurisdiction wants to, is looking at potentially allowing some building permits, those locals will look at this information on a website, or how will that work?
So this wouldn't be so much for building permits and things that are just handled at the county level. This is only things where the department is issuing a permit.
Department of Environment.
Department of the
Just
Environment.
Okay.
And so it's whenever MDE is required to publish notice, so it's in 2 consecutive weeks in the daily newspaper. The notice provisions are limited to things right now where they're required to do this sort of public notice about a permit application.
Okay.
Yeah, Senator, it's to force the department to use this as a lens. So when there are permits for a plant that's going to discharge something, I mean, when they decide on approving it, one of the problems has been a lot of things that emit this or that, whether it's air or water, is falling in some poor communities, basically. Lots of times, communities of color. And I think this is to get a lens to the Department of Environment to look at whether all they're doing is approving permits that are going to have some significant discharge, for example, that continue to fall in the same neighborhoods. I mean, that's how I read it. I don't want to read into it. I mean, Senator Ellis, it's your bill if you want to, give any other explanation, obviously.
That's an excellent explanation that you just gave. And so we have this tool, University of Maryland screening tool, the Federal Environmental Protection Agency have these tools, and they're just sitting out there by themselves. So what this bill and what the climate change bill did, requiring this is say, hey, everyone, pay attention to this. It's there, let's use it and have it to look at when we do these permits.
Okay, on the bill, that'll be recorded 10-1 and report to the floor with a favorable. We're down to our last 2. I am going to hold the Attorney General's bill on that one issue. Okay, we addressed the other couple of amendments. We adopted one, we rejected 1.5. And so there's a half of one left. We're hopefully next 24 hours, we'll get a very explicit answer to that, and then we'll move it tomorrow. Okay, we have 2 bills left. 711.
Senate Bill 711, Health Occupations, Licensed Athletic Trainers, Dry Needling Registration. This bill authorizes the State Board of Physicians to register licensed athletic trainers to perform dry needling, establishes qualifications for registration, which include the completion of 80 hours of education, 40 hours of which must be hands-on instruction under supervision, deems a licensed athletic trainer who completed coursework before 2018 to have satisfied certain requirements. If the course was substantially similar, exempts out-of-state dry needling practitioners from registration if certain requirements are met as well, imposes disciplinary procedures for wrongful practice, and a $500 fine for an individual who practices without being registered. There are one set of sponsor amendments that were passed out alongside the thicker packet. The number ends in 393725. And these amendments are on request from the Board of Physicians, and essentially they require a licensed athletic trainer applicant to submit a specialized task for the board to approve instead of requiring a separate application and a separate evaluation and training protocol. And essentially, Board of Physicians told me that this was because they already have to do the evaluation and training protocol, so to make it separate was redundant. It removes the exemption for those who completed coursework before 2018 and removes exemption for those practicing out of state. It removes the fine and removes the additional disciplinary procedures by merging them with pre-existing disciplinary procedures.
Favorable?
Is there a second?
Unfavorable? Unfavorable. Move to unfavorable.
Yeah. Discussion. You want to explain why, or somebody who likes it want to explain? I mean, it's open debate here.
So Washington, you want to start? So
Well,
Washington has her.
one of the opponents like to at least explain why not, and then we'll go. I assume you want the bill. We'll go to you next.
For me, this is similar when we were talking about the, sort of podiatrist versus a physician and, all of that. And so dry needling, I've had all of it, it does involve, I think, it does involve a level of training and education and risk. You are putting needles into the body. It's sort of a step down from the original practice of acupuncture, which is even more sophisticated and requires a lot more training. I think it should be done in a therapeutic context. So that's why I think it's important. And also, lots and lots and lots of my constituents also think that it's important that it stay as well. I got so many emails about this, more so than I've gotten some other things. So, so that's why I oppose it.
I like this bill. I know when you get into kind of these, for lack of a better term, turf things, it's, hard sometimes for change. But, I was just thinking of the testimony we had from the trainer from the Ravens. I thought that was good. These athletic trainers, I think they're more than capable of doing this process. And I also got the opposition emails and calls, but it's pretty much all coming from the acupuncturists who, in a turf battle, they're not going to give up any turf. So of course they're going to oppose it. So, I was impressed enough by the different trainers that spoke that they're doing this the right way. And especially the Ravens trainer, I really liked what he had to say. So I would be, in favor of the bill. Against the unfavorable, but I didn't get a chance to move favorable. The vice chair was too quick on the draw.
Now, let's hear from other people. We'll come back. Senator Corrosive, Senator Riley, and back to Senator Washington.
Thank you, Mr. Chair. I just wanted to share with my colleagues that I did a Zoom meeting with the UMES students from the Health Professions School who were strongly in favor of this bill, as well as wanting to share with you that those of us who have worked closely with the athletic trainers know of their professionalism and their expertise and strongly support this. And there was very compelling testimony, so I will be voting against the unfavorable, and I was very surprised that it was moved like that.
Thank you, Mr. Chair. I'm not surprised it was unfavorable. I got a bunch of phone calls and emails from acupuncturists. But I have a question for council. In the past few years, have we given this authority to physical therapists and chiropractors?
We have.
Okay. So again, this licensed athletic trainers is another highly qualified group of people who do significant amount of training. I think it's a logical step along with physical therapists and chiropractors. So I'll be voting against the unfavorable. Thank you, Mr. Chairman.
So one of the questions I asked during the hearing was who were the clients of the athletic trainers? And I believe that their answer was that it was only the athletes that they were going to be treating and not like the general public. And so that kind of made me feel like, well, it's a very specific, group that they're treating. And so why not let them, take care of their athletes, give them one more tool in the toolbox? And so I haven't decided how I'm voting yet, but I just wanted to ask council, if you are an athletic trainer, will you be able to do this on anybody, or is it just on the athletes that you're training?
The scope of practice for athletic trainers are just those people who are considered athletes.
On their team, right? It could be, it doesn't say restricted to your team, right?
Be a professional team, for example, but within the definition of that scope, they're authorized for individuals who are defined as
Right.
athletes. So it would have to be a team of some sort,
So-
athletic in high school,
Yeah.
college, professionally.
So there could be a practice of athletic trainers who could set up a practice to provide services
Oh, sure.
to athletes. Yeah.
Sure. Mhm.
Yeah, okay, thank you.
Yeah, thank you, Mr. Chairman. So, Ms. Foxworth, how many other states authorized dry needling for athletic trainers? I know we talked about it
Yeah.
in the hearing.
That
Do you remember
is
those numbers?
a great question. I think they mentioned that at the hearing, but I do not recall. Let me see.
But it seemed like quite a few other states do
Yeah,
authorize it,
I think
right?
they mentioned over 20 at the hearing, but I would have to go back to confirm.
I think Senator Riley, remember the
Oh, it's
number?
apparently 26 states. Apparently 26.
Oh, 26.
Yeah.
The testimony from the Ravens athletic trainer is, I could do it in this state, I can't do it in Maryland.
Yeah.
So as they move around the United States playing football games, they're authorized in some states, but not in Maryland. Thank you, Mr. Chair.
Yeah, so 26 states doing this. And so do you remember the requirements for athletic trainers in Maryland for training experience? Is it similar to those other states?
Now, the training and
You
experience,
might-
I'm not so sure.
Yeah.
Yeah, I didn't pull the interstate assessment from the
Yeah.
others.
Okay. I'm curious, yeah, I'm sorry, go ahead.
Oh, no, I can take a look at one of those states really quick, though, to see, but I do not have that right now.
Yeah. I'd love to know if the requirements Maryland have to be an athletic trainer is similar to the other states that have okayed this practice. I mean, do we have that information, Mr. Chairman?
I don't know definitively, Senator, but I would say it's probably in the ballpark of a lot of states, because when these bills start to happen in certification, it usually happens on a national level. So I can't say that with any kind of confidence, but generally, I would think a lot of the other states, I mean, it took us a while to certify athletic trainers. I mean, that was a debate with physical therapists for a number of years in our state.
Yeah, so they're certified in Maryland.
I believe they are.
As in
They're licensed,
certified, yeah,
actually.
they're
They're actually
a
licensed.
licensed group within the state.
So
Yeah.
you're saying? Okay.
They went through a process, Senator Lamb might add to this, but this was a debate for a number of years.
Yeah.
And some people tried to stop them, and they have certain training they have to go through.
So athletic trainers are, you said, licensed in Maryland, and there are specific training and experience that they have to be licensed. Okay, but they are. Great, thank you. Appreciate it.
Colleagues, so I think that the question is the training for athletic trainers the same or similar to physical therapists? So we've extended it when we've somehow been satisfied that the training was equal. And, you know, while maybe so I'll make this first point. So the first is that the physical therapist, it's just a degree and a certificate, where a athletic trainer is just a degree and a certificate, and a physical therapist requires an advanced degree, right, and more training. And they also have to be able to diagnose and treat patients who are injured. So they have a different skill set. Also, I don't think we should say that the people who are going to be out there using dry needling on our sons and daughters and people, you know, out in the field are at, no offense, but at the same level as the Ravens, you know. So I don't think we should extend a practice to a whole discipline on the basis of the elite trainers that are in professional sports, because this isn't restricted to professional. It would be for every team. So that's my reason.
Couple more speakers. I know everyone is waiting on pins and needles. Sorry about that. Senator Corroza, I'm sorry. Senator Corroza, the Vice Chair, then Senator Hester, then we'll just vote it up or down.
Thank you, Mr. Chair. Going back to Senator Ellis reminded me to go back and take a look at the testimony. In the testimony by the Maryland Athletic Trainers Association, a 2019 study showed that approximately 89% of the skills required for dry needling treatments are taught during professional entry-level AT programs, and then the remaining 11% of those skills through dry needling educational courses, and this percentage is higher than physical therapists. So, you know, again, I think going back to the professionalism and training of these athletic trainers.
Not comparing it, though, to physical therapists, so I'm not sure how that gets woven in. I think about this in terms of risk. If I go to someone who's a licensed masseuse or masseur, I know I'm going to get a really good professional massage. And if I go to someone who's not licensed, I might not get a good massage, but I'll get a massage. If I go to an acupuncturist, I know that she or he is going to know where to put the needles and where their placement is going to make a difference for my health. If someone puts a needle in the wrong place, I could have lifelong pain, I could have paralysis, I could have, the risk is enormous. And I don't want a random person, sorry, that is too disrespectful. I don't want someone who isn't trained to the nth degree putting needles into someone with the possible risk of lifelong damage. That's why I have concerns about this. I want people who really know what they're doing, and this is their only expertise.
So just going off some comments earlier when you talked about, if it's not the rate, not professional, well, University of Maryland, same thing, this guy for the football team there, he could do it when he's in Michigan, but can't do it in Maryland, which, doesn't make sense. But if we go down to the high school level, wouldn't someone under 18, any kind of this, have to be approved by their parents? I mean, I think that's kind of muddying the waters a little, but it's not just the professionals like the Ravens. I mean, you can look at the testimony of the University of Maryland, go Terps, where this gentleman could do this when he was in Michigan, but can't in Maryland. It's just, that doesn't make sense to me. And like I said, it's turf battle. Some people that might not have the amount of trust that I do in these athletic trainers, but I think they're more than qualified to do this, so I'll leave it at that.
Question. Does the bill, because it raises an interesting thing, if the athletic trainer for a team, if they are going to apply an ice pack or wrap a broken knee or any of those type, are they required to notify parents? I mean, is there a requirement that if this athletic trainer is going to place a needle as a part of now what they're illegally allowed to do, is that required that parents notice? So thank you, Senator Gallion, because I didn't even think about that.
Like a specific notification
Yeah,
requirement to
there's no,
parents
right,
within
so
the
they could,
code,
just like they wrap a knee or put ice on, this would just be considered something that they can do regardless of the age of the child at this point, it seems. There's no, in other words, this doesn't say for 18 years old or above.
Right,
Okay.
that's correct, yeah. There may be
Thank you.
additional requirements within the school, but
Yeah,
in general,
but anyone
it's
could do
not
it to any
specific.
child, yeah, thank you.
Sorry. I wanted to offer a conceptual amendment that, that if it's a professional team that travels out of state, that athletic trainers are allowed to do it on their athletes. And my justification for this is that these athletes are probably going to get more hurt playing their sport than they are with a trainer who they know doing it on them. So that would be my conceptual. Oh,
Yeah, that's right, and,
I tried.
okay, and look, if the unfavorable goes down, we can offer amendments. But I have to say, you've got college sports where they're traveling, and this isn't done right on the field. This is more therapeutic, right? I mean, this isn't, it's into the muscles where they can't reach them. So I think either support it, oppose it, do whatever you do, and then I think we should, if the unfavorable goes down, we should move the bill. But that's a call. Let's go to the roll call.
On the unfavorable? Senator Kagan?
Yes, on the unfavorable.
Senator Kagan, yes. Senator Lamb?
So I'm going to vote no on the unfavorable, but I've gotten an earful from both sides, which is why I've not kind of weighed in on this. I've gotten a lot of mixed results, but no on the unfavorable.
Okay, Senator Hester?
No on the unfavorable.
Senator Esther, no on the unfavorable. Senator Ellis?
Explain my vote. It'll be no on the unfavorable in that we can look at using the professional team as a guinea pig in Maryland and then come back and see, how it works and expand it to the college teams if necessary and others.
Senator Gallion? No. Senator Gallion, no. Senator Corrosa? No on the unfavorable. Senator Corrosa, no. Senator Washington?
The unfavorable, because currently as drafted, it could be used on 18-year-olds, and I'm open to the negotiation.
Senator Riley? No. Senator Riley, no. Yeah.
The unfavorable goes down. Sure, why not? Sure. Sure. Senator Patterson.
Senator Patterson, no. Your vote. No, I'm asking you. I'm sorry. It's just. Okay, Senator Patterson, no. Senator Salmonair? Okay, Senator Salmonair, no. And Senator Penske? Senator Penske, no.
For us is a favorable.
Given the fact that we have completely carried out this vote, will she be out of order to put in a substitute motion?
No, the bill's before us.
Okay. You can do it.
So it's been moved and seconded. Senator.
I don't,
Right now, the bill before us is a favorable. People can vote against if they hate it. If people aren't totally satisfied, they can offer an amendment, but we don't want to sit here a long time. Okay, seeing no amendments being offered, let's go to a roll call.
All right, Senator Kagan?
I have a question. We have vital amendments in front of us.
Thank you. Thank you. Whoops. The sponsor, she is the sponsor, right?
She is.
Yes, there are amendments, thank you.
I'm going to move the vital amendments.
Okay, and what do they do briefly?
There being a separate entry into an evaluation and treatment protocol, which is basically the agreement that an athletic trainer has to go into with the physician. The pre-existing evaluation and treatment protocol, they just have to indicate that they'll do a specialized task that is dry needling, instead of entering into a separate one. And then it removes the exemptions for individuals who are practicing in another state or who have completed coursework before 2018. Under the bill, they would have been exempt from registration, and it removes that exemption. So folks coming from other states will have to do the specialized task, evaluation and treatment protocol, and satisfy the continuing education requirements.
Thank you very much. So, counsel, you're saying that these people have to take an exam, have to be under the Board of Physicians, and they have oversight?
They will. They'll have oversight. They have to do.
That's fine, that's fine.
Okay.
So some comments were made about anybody can do this, and, you know, it'll open the doors for anybody. And I'm, just want to verify, there is regulation, there is oversight, there is exams. Thank you very much.
Absolutely.
Objection to the vital amendments? Okay, the vital amendments are adopted. The bill is amended. Discussion. Roll call.
Senator Kagan?
No.
Senator Kagan, no. Senator Lamb? Yes. Senator Lamb, yes. Senator Hester? Yes. Senator Hester, yes. Senator Ellis? Yes. Senator Ellis, yes. Senator Gallion? Yes. Senator Gallion, yes. Senator Corrosive? Yes. Senator Corrosive, yes. Senator Washington? No. Senator Washington, no. Senator Riley? Yes. Senator Riley, yes. Senator Patterson? Yes. Senator Patterson, yes. Senator Salmonair? Yes. Senator Salmonair, yes. And Senator Penske? Sure. Senator Penske, sure. 9-2.
Okay, let's, it passes 9-2.
Yes, 9-2.
9-2, it passes. I had skipped Senator Sidnorth Bill 413. That is,
Senate Bill 413, Voting Rights Act of 2022, Counties and Municipalities. This emergency bill establishes a specified prohibition against the impairment of the ability of members of a protected class to elect candidates of their choice in elections in a county or a municipality, or to influence the outcome of such elections. It includes factors, considerations, and criteria related to the establishment of a violation of this prohibition, and authorizes the Attorney General to enforce the prohibition. This bill does not apply to statewide elections. The only amendment is a co-sponsor request from Senator Jackson. So,
try it again.
okay. So what the bill does, it says the Voting Rights Act, and it prohibits a county or a municipality from setting up in an election a way that would prohibit or impair a protected class from the ability to elect candidates of that member's class or a candidate of their choice. And it allows essentially, it's like a Voting Rights Act for counties and municipalities. So you couldn't organize your method of electing the governing body of a municipality to drive out black voters in that county, or prohibit them from, or setting up your district so that it would prohibit them, that particular class, from being able to elect a candidate of their preference.
One more question, and I'll get to these two. So it's for county elections and municipal elections?
Correct.
So it tries to apply, it's proposing to apply the Voting Rights Act to counties, so people are not discriminated against when redistricting, for example.
Correct.
Okay. I'm not sure who I saw first. Ladies, whoever wants to go first.
Yeah, I was just going to say, I see this
We'll get these two and then
as
we'll move on.
Maryland's affirmation of the Voting Rights Act and extending that to our counties and elected, and also all protected classes would also involve, right, persons with disability, like, who are the protected classes? Would it also persons with disabilities, any?
Race, color, or language minority group, as this class is referenced and defined in the Federal Voting Rights Act of
Federal, great.
1965.
Yeah, so it's exactly doing that.
Right.
Okay, thank you.
Thank you, Mr. Chair. And my question's along the same lines, because I pulled up the testimony and saw Disability Rights Maryland. And I just didn't know, did something prompt the bill at this time that just for informational purposes?
The sponsor proffered in his testimony that the redistricting in Baltimore County influenced his decision to put in the legislation at this time.
Thank you. I brought this up, I think I asked about it in the hearing, about the bill not applying to statewide elections. My question is, and he said, well, it's more or less it's in the committee's hands. Why wouldn't we want to apply it to statewide elections? I mean, isn't that an issue statewide? I mean, we've heard the news about the courts kicking back these different maps for these kind of issues. Why would we just want to do this? I guess a committee policy question. Why would we just want to do the counties and municipalities? Why not statewide?
I don't have an answer to that.
I know over the current court case in front of a court of appeals, I know people have looked at it to see whether it complies with the Voting Rights Act. So I know, I mean, I think I heard the Senate President at one point say that the Attorney General's office have reviewed it and they think it complies, well, maybe not the Voting Rights Act, but with the state law, that it's constitutional. Beyond that, I don't have an answer for you, Senator. Senator Ellis.
Thank you, Mr. Chairman. So I have a question for council. So the title of this bill is the Voting Rights Act of 2022. So I know at the federal level, acts expire after X number of years. Is that the same at the state with a law versus an act?
The law did, no, it's just, that actually just references the year in which the legislation was passed. The law does not expire unless there's a termination provision on the effective date of the law.
Yeah, so I wasn't referring to 2022, but just the term act, has a different meaning at the federal level. And like the Voting Rights Act expired and has to be renewed every, I don't know, X number of years at the federal level. But you're saying
This would be permanent.
this is permanent, it's just a word in the bill.
Yes, sir?
Great, thank you.
I'm really interested in this. It says specifically that it doesn't apply to statewide, as Senator Gallion said, but there's a loophole that doesn't say state. I mean, where state and not statewide? And there are a couple of other questions. There was no opposition, so I don't have, particular concerns about the bill. I just would like to understand it better, and I would ask if we could hold it a day or two.
Okay, we'll hold it till tomorrow. Now, we're done our list. Let me tell you what I have for tomorrow. I've got 5 bills that we addressed tonight, just so we're all on the same page. Which is, yeah, we're gonna hold that till tomorrow. We've got the athletic thing that you guys are gonna see if you can quickly resolve it, hopefully quickly. We have, hold on. We have the AG bill on enforcement. We're waiting on the answer to the last amendment, or half of an amendment. We have, Senator Ellis raised a question about hunting and the liability question. That's 3. We have the bill we just didn't get to because it's late and I want to let you guys go. Oyster, spat, shells, and substrate from Senator Elfrith. That was on the list today, we didn't get to. And then we have the Voting Rights Act. So we've got 5 bills. Huh? No, that's done. Okay, look, those 5 for sure. Some others might be added, even tomorrow morning. I just have to see what's left and how much time we have. Those 5 for sure, between hearings and our second session. Okay? Now, final point, as we pass bills, I'm going to have to meet with committee council and we'll sign them. We're going to be running fast and loose in the next week. We will try to get them to you as soon as possible, so you have a little heads up. I know Senator Patterson and we had some miscommunication, but I had some backup files, and I do always have backup files if you don't have your file. So that's where we are. We got a lot done. We're still way ahead of everyone else. Thank you for your great work. Have a good evening.